Do we have too much government?
We need to put people ahead of corporate profits.
This system is so lopsided.
This threat is a real threat to democracy.
And I think that's really important. That's something we haven't been doing in this country for a long time.
Where do you start? What do you do? How do you do it?
Access to Democracy and other Eagan community television programming is supported by Thomson Reuters, makers of Westlaw Next and based in Eagan. Through Westlaw Next and other innovative online services, Thomson Reuters is the world's leading source of intelligent information for businesses and professionals. Online at thomsonreuters.com. And by U.S. Federal Credit Union, the member-owned financial institution offering service, value, and experience you can trust to the greater Twin Cities community.
Welcome back to Access to Democracy. Happy to have you back viewing with us, and I'm really happy to have, for his first visit since ascending the Supreme Court bench, the Honorable David Lillehaug.
Thank you, Alan. Great to be with you.
You've been on the program several times in the past as a practicing attorney, as handling the Franken lawsuit, which resulted in his moving into the Senate, and now, appropriately, a litigator moves to the Supreme Court.
And you're so much more respectful, it's hard to believe.
We have to give deference where deference is due. One of the interesting things that I've noticed since you became, I guess you were sworn in on June 28th, but you were actually nominated on the 3rd, is that you hit the ground running.
Yeah, actually I was sworn in privately on June 3 of 2013. I had a private swearing-in ceremony at 8 in the morning. I was hearing my first case at 9 and then voting on the first case at 10 o'clock. And by the way, it turned out to be a 4-3 decision, so yeah, I was thrown into the deep end of the pool on the very first day. And I'm also the only justice on the Minnesota Supreme Court to come directly to the court from private practice. So yeah, it's been a wonderful but very big transition.
But not so big a transition because of the number of times that you argued in the Supreme Court and in appellate courts. That part has to be pretty normal for you, except that you're on the other side of the bench.
Yeah, I mean, I was very lucky to have a very good litigation practice, not just in the commercial area, but in some of the public law, big type cases that you have mentioned. So I knew the Supreme Court pretty well, had studied all of the justices pretty well, and of course had submitted briefs and arguments. But it really is different on the other side, because the moment you raise your right hand and you walk through the door and you put on the black robe, it's a different world, and I'm looking forward to speaking with you about that today.
And it's a different world in that the political side of your life is over.
It is over. It is over. When I was referencing raising my right hand and taking the oath, it's a serious oath. And what you're essentially saying is your fidelity now is to the U.S. Constitution and the Minnesota Constitution and doing justice. Your fidelity isn't to politics, it's not to personalities, it's to precedent, and it's to principle. Those are the things that are guiding me in my work now.
Now, how did you find the adjustment to leaving private practice and entering the court?
Certainly the pace is different. You know, in private practice, especially in the last 10 years with the internet, cell phone, you know, it was sort of 24/7 in the service of clients and pro bono work and bar activities. It's a slower pace in the sense that the phone doesn't ring all that often. It's a slower pace in that there are really very few emergencies. The Supreme Court isn't just writing or thinking for today or tomorrow. It's supposed to be thinking for the next 100 years. So that's different. What I have found interesting is that there is time to think, there is time to contemplate, and there is time to do things right. And that's a part of the job that I really like.
And now you've been in some cases in the last few days with very divided courts, and we'll talk about them in a few moments, but there are judges thinking that they're doing things right, who disagree with you, who think you're doing things right, and that's what makes for 4-3 decisions.
Well, that's why the Minnesota Constitution put a number of justices on the Supreme Court. It used to be 9, now it's 7. And yeah, we've had some 4-3 decisions, but when you look at the court over time, there's a pretty consistent pattern that about 3/4 of the time the justices agree with each other. You'll get a unanimous decision. But the cases that we take, and we take only about 1 out of every 8 cases coming out of the Court of Appeals, they're the hard ones. And so good people in good faith can disagree, and sometimes very vigorously. We just try to make sure it's never personal.
Now, talking about the Court of Appeals, somebody loses in the Court of Appeals, they want to go to the Supreme Court. How do you make the determination as to which cases go to the Supreme Court and which don't?
The party that wants us to take the case from the Court of Appeals, and sometimes, by the way, it may be both parties, neither party may be satisfied, they file what's called a petition for review. And we go over those twice a month. Next week, for example, we're going to be looking at 33 petitions for review. They file a paper, we take a look at the Court of Appeals opinion. Each party can file things telling us why we should not take the case. How do we decide which of the approximately 1 in 8 that we take? Well, we're looking for cases that have a statewide impact. We want every case to be decided correctly, of course, but at the level of the Supreme Court, you're making the law. You're interpreting the law in the final way. So we want the case to have statewide impact. There may be a conflict between different decisions in the Court of Appeals that has to be resolved by the Minnesota Supreme Court. That's another kind of case that we will want to take.
Of course, there may be a conflict as to between 2 judges as how they read cases which become precedent.
That's exactly right. On the Court of Appeals, you've got multiple judges, different 3-judge panels, and those panels can sometimes reach different decisions on the same issue of law. And then finally, there are just some cases that the legislature has said that we absolutely must take. For example, if someone's convicted of first-degree murder, the appeal of that conviction goes directly from the district court to the Minnesota Supreme Court. It doesn't stop in the Minnesota Court of Appeals. So we handle all first-degree murder cases, both those coming directly out of the district court, and then also petitions for post-conviction review, which we think of as habeas corpus type petitions from people who have been convicted of first-degree murder.
Yeah, I just heard on the news yesterday, as a matter of fact, somebody who was convicted 7 months ago is now petitioning for review of his case. It was a wife murder.
There are very few first-degree murder cases decided by trial that don't eventually get to the Minnesota Supreme Court. The first major opinion that I wrote was in a first-degree murder case where it came out of Mahnomen and Polk counties here in Minnesota, of course, and it was somebody who was convicted of killing a deputy sheriff. So very, very serious cases that go directly to the Minnesota Supreme Court.
Was that the Fairbanks case by any chance?
Yeah, it was called State versus Fairbanks, yes.
How's that?
Very good, yeah.
Do a little bit of homework.
Props to you.
Yeah, that was a murder first case. Police officer, change of venue was a big question there.
That was one of the issues in the case.
And
whether the change of venue from one county to another had been proper in light of pretrial publicity.
And how did that case end up? I know the final decision just came down a couple of days ago.
In a unanimous decision, and I wrote the decision, the court affirmed the conviction, overturned the conviction on one assault count, but by and large, what happened before the jury in the district court was affirmed.
Now, how is it decided who writes which decision, who gets which decision?
Well, this is all public knowledge, but it happens behind the scenes. Typically, one justice is given primary responsibility for a case. And so the justice and his or her law clerk will prepare a memo that's provided to all members of the court. Now, that doesn't mean that the individual justices don't do their individual research, but it's a starting point. And then, of course, the justices all, and I can say this uniformly all, read the briefs in the case as well. The case is argued, oral argument, we could talk a little bit more about that, but afterwards we get together in a conference room outside the courtroom, but in the Judicial Center or in the Capitol, depending on where we've heard the case, and we talk about the case and then eventually we vote. If the justice who had primary responsibility for the case is in the majority, typically she or he will be writing the majority opinion. But sometimes that doesn't happen. So then typically the most senior justice in the majority will have first crack at writing the majority opinion, but it can be assigned to someone else. It depends on the circumstances.
So those conferences take place right after the argument is
They
heard?
take place right after the argument. We want to make sure it's fresh in our mind. And that really is the first time when we all sit down together as a group, the 7 of us, with no outside people in the room, and we talk about the case and we try to get to justice.
It's very much the same as the model of the U.S. Supreme Court.
Oh, exactly.
Except that they generally talk about the cases 2 days later after argument.
It's a very formal process. That's one difference between private practice and being in the court. In private practice, when I had a big decision to make, it might be kind of a rolling meeting. I'd bring in 3 or 4 people, I pick their brains, maybe 3 or 4 others, reconvene the group, maybe make a phone call late at night, and eventually arrive at a decision. This decision-making process is different. We typically don't deliberate about a case until the oral argument occurs, and then we're together in the conference room with all 7 of us, because the theory behind a court with multiple members, and I have found this to be absolutely true, is that the members bring a diversity of background and experience to the deliberation. And there is sometimes a kind of magic that occurs when you get 7 people all thinking hard about a case and an issue, all bringing their entire life body of experience into that conference room. That's how we do it.
And the Minnesota Supreme Court has a reputation of being one of the finest, really, appellate courts in the country.
Knock on wood, may it continue to be so.
May it continue to be so.
I'm very proud to have been appointed to this court.
There are certain courts, like the New York Court of Appeals was always considered, in years past, as one of the top courts in the country, and several others.
Yeah, and one very important ingredient to maintaining that is respect and collegiality among the justices. We all come to the court from different places. Appointed by different governors, and in one case not appointed by a governor but coming straight through the election system. And there will be disagreements. There were a couple 4-3 decisions this week. But even when there is disagreement on the law, everybody is deeply committed to the principle that we are courteous with one another, we respect the backgrounds of each other, and we work in good faith to try to come to agreement. Sometimes you can't get there.
Well, you succeeded one of our favorite guests, Paul Anderson.
Paul H. Anderson.
Who had just a wonderful reputation. And one of the things he always said, which was backed up, I had Justice Strauss in here and Justice Wright in here. I guess probably we've
all come to see Alan Miller.
6 or 7 of the judges. We have one judge who's going to retire next year who has not come yet, but he doesn't like
Well, I think
public
this is the
appearances.
15th anniversary of your show. I figure when you finally retire, we ought to present you with a black robe.
Well, if we can get somebody to come in, and actually, I sat in a moot court argument in the Supreme Court as a, quote, justice.
So you've been behind the bench.
A few times, but recently on, I'm trying to think, it was Al Weiwei case, that the Chinese dissident, and we re-argued the appeal there before 2 law school groups, and it was very interesting. Yeah.
Well, you mentioned Paul Anderson. He is my predecessor, and I'm very honored to have the seat that he had. And he succeeded one of the legendary lawyers in Minnesota, John Simonette, who died a couple of years ago, and I think may have been the best opinion writer in the Minnesota Supreme Court. I read his stuff, and if someday I could get anywhere within the ballpark of John Simonette and Paul Anderson, then I would think my time on the court to be a success.
Well, I think background-wise, and from what I've seen, you have a good chance. And
Thank you, sir.
So, other than
Okay, now that we've complimented each other.
other than that, you talk about collegiality.
Yeah.
So you walk in, and there's a justice, and you just differed on a 4-3 case. In fact, Justice Strauss, who I have great respect for and who was here, actually has broken bread with us in our home. took exception in two places in a case that came down this week to, I think it was your dissent.
I guess technically I took exception to Justice Strauss's majority opinion, yes.
Where he specifically said in his footnotes, Justice Lillehaug misconstrues this or something to that effect, only he does it with a lot more sophistication than I do.
And there is nothing personal in that. One thing that troubles me sometimes when I read U.S. Supreme Court opinions over the years is the snarky footnote.
I think that's more prevalent lately. And I think as Justice Scalia gets older, he's much more prone to really vent his spleen in some of his footnotes.
Well, I'm not saying this will never happen, but my goal is not to vent my spleen. I think what I tried to do in private practice was be courteous and professional. You can be a strong advocate for a position and yet do it in a courteous way. And I'm hoping that my opinions, and I hope I'll be able to be on the court over the next decade, will reflect that. There is that temptation, you know, when you got the ink or the electrons, you want to use them and spill them. My goal also is not to write too much. You know the old saying, what was it, Ben Franklin, I would have written you a shorter letter, but I didn't have the time. I think it was Ben Franklin, I'm not sure. We can Google that. That's kind of the way I feel about judicial opinions, that if you can make your point, make it clearly, concisely, make it so that somebody 100 years from now will be reading it and understanding it, then you're successful.
Now, people have said to me at times, how did that judge know what the other judge was going to say? They don't have the concept that decisions are circulated around before they actually finalized.
Oh, that's a good point. I was describing the formal decision-making process.
Yeah.
After the justice is assigned to the majority and after justice is assigned to the dissent, and there may be more than one dissent, then there's a very formal process where after the majority opinion is drafted, it's given to the dissenting justice, writes a dissent, then goes back, and those two will keep going back and forth until they've had to say what they want to say. And then you take the package and then you move it to another justice for review, and it goes up or down the chain depending on where it started, because we're very seniority oriented. Things move up and down the chain in order of seniority. And then justices will decide, do I join the majority? Do I join the dissent? Have I changed my mind from the time of the conference?
Which happens at times.
Sometimes, yeah. Not a great deal. Most justices, when they cast their vote in conference, it's a tentative vote. You can change your mind right up until the last minute, but if you've thought about it carefully and you listen carefully to the arguments of your colleagues, often at the end of the process, you are where you were at the time you voted.
Now, the decisions of the U.S. Supreme Court are generally announced from the bench, although it's rare for a justice to read his or her decision.
We don't do that.
That's not, I was just going to say, that's not the way it's done here.
We don't do that. If you're interested in the Minnesota Supreme Court, what you can do is at 10 o'clock every Wednesday morning, go to the Supreme Court website, and by the way, I've done this waiting for decisions when I was in private practice, and I would click refresh, 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 and then boom, all of a sudden up pops the decision. And
Wednesday is decision day.
Wednesday is decision day.
And it comes out of the clerk's office.
It does, yes.
Yeah.
And of course, we get a heads up the day before which decisions are coming out, which have been finally completed and site checked, and hopefully everything is in good order. And for a practitioner, that's an exciting moment when you get a Supreme Court decision. It may be a big high or it may be a big low.
Now, the decision that came down yesterday, People against Nelson, was a hotly contested decision in the Supreme Court. Here's a guy who didn't pay child support for $83,000 worth of non-support. And the court was very divided on it.
It was a 4-3 decision.
Right, as a question of the statute, interpreting the statute. Does the statute say duty or care? Or does it say duty and care?
Care and support were the two words.
Care and
Yeah.
support, my mistake. And how do you work that out?
Well, the court speaks through its decisions. Individual members don't usually go out on the speaking circuit or even to the Alan Miller show and explain the rationale behind the majority opinion or the dissent.
We never talk about pending cases, so that's...
No, but even with regards to cases that are handed down, we speak through the words in the case. So what I'm going to say is just comes strictly out of the words of the case. The issue was there was a statute saying that if you knowingly fail to pay, or if you knowingly fail to provide care and support, then that can be a felony. And that's kind of the end of the road in the child support collection process. And
It's really very important because there are billions of dollars of uncollected child support.
precisely
out
the
there,
point I made in my dissent.
which, gee, funny I should mention that, which fall then often on the state to have to help the party who really is in need of help.
And this was a statute that was passed in 1963, but one thing about the practice of law, even statutes that have been around for a while, lawyers who are zealously representing their clients will take a real careful look at the statute, and if they see some error in it, they'll try to make a big deal out of it. This case involved the interpretation of the statute. Does the prosecutor need to prove that the defendant not only failed to pay child support, but also failed to provide care for the child? And what does care mean? And
So that
the Justice
that
Strauss,
defendant who picks up his child once a year but is still not paying support might, in the interpretation of some judges, as was the case, be giving care.
that was one of the arguments that was made, yes. And Justice Strauss, writing for a 4-justice majority, held that you have to prove both, which I think everybody acknowledges would be very difficult typically for prosecutors to do. My dissent argued that the failure to pay child support in and of itself was enough. We had a disagreement, the case is over, the law of Minnesota is now established, and we move on.
And now it's up to the legislature to change the wording of the statute if in fact they want to make sure that the non-provider of support for the children doesn't get off the hook.
That's one of the beauties of the separation of powers that we have in our federal and Minnesota constitutions. And in my dissent, I observed that in the absence of swift legislative action, Minnesota could be the only state without a criminal child support statute.
Which I hope they address this year.
That will be up to the wisdom of the
The
legislature.
Minnesota Supreme Court does not make law. I think that the United States, this is me speaking and not you, the United States Supreme Court in recent years under the Roberts Court has made some law, and I find it very inappropriate. And again, that's just, you don't even have to comment on
it
it.
kind of depends on how you interpret the phrase "make law." The legislature cannot cover every
I'm
situation.
thinking
in
of
statute.
Citizens United, where they come out with a decision beyond anything that was asked.
Well, most certainly that case was a situation where some longstanding precedent was overruled, and done so very straightforwardly. It is an unusual situation when the Minnesota Supreme Court overrules a precedent. We operate on the basis of precedent. We honor the doctrine of stare decisis, the cases which have gone before, try to interpret the cases that have gone before, apply them to the facts and circumstances at hand.
Now, there was another case yesterday, the Vassallo case, which again was a very interesting case. A deputy is responding to a call, and at one point, I guess he had his lights and his siren on. At another point, he cut the siren, and he broadsides a woman in an intersection who apparently will be certainly an invalid for the rest of her life. And the question is there immunity to somebody performing their duties in the course of their business? Or
another interesting case in a complicated area of law. The one thing that unites the two cases that you and I have just talked about here is not only the fact there are 4-3 decisions, which doesn't happen all that often, as I've mentioned, but also they had to do with some very fine parsing of statutes or regulations. A lot of what we do is take the statute that the legislature gives us or the regulation that comes out of an executive branch agency, and we try to figure out, what does it mean? Is it plain and unambiguous?
In many cases, it's
clear?
not.
Well, and then if we determine that the statute or regulation is ambiguous, the legislature has actually given us a law telling us how we should interpret ambiguous statutes and regulations, and how we ascertain what the legislature really intended.
Well, then you look for intent.
We look for intent, and there are different factors that we apply in trying to ascertain what the legislature is telling us, because, you know, as your point is, fundamentally they make the laws, fundamentally we apply them, although you can argue about what happens at the intersection of the two.
And in that case, it was held that the immunity for the public officer was, in fact, the precedent.
That the officer was undertaking a discretionary function. And, you know, a very difficult and in some ways heart-rending case.
And that's what the big bucks are for. The funny thing is, the big bucks are much less for the members of the court than they were when they were in private
I know you're just
practice.
joking, but it has nothing to do with the bucks. It has to do with principle and precedent.
And, well, it's really interesting. And the thing is, you can be arguing really vehemently in a dissent or in a majority opinion, and you'll certainly just have the best of relations with that person the next day.
You try to, and you work at it, and happily the tradition on the Minnesota Supreme Court has been one of collegiality. There are some states, including one next door, where at some point it is alleged that the justices are at each other's throats.
Literally, with hands around the throat.
Yeah, I probably shouldn't have brought that up, but that has not been the tradition in Minnesota, and again, we hope that it stays that way no matter which justices are on the court appointed by which governors.
What do you think are the toughest cases? And we only have a minute left. I was just signaled. A lot of things I wanted to talk to you about, so maybe we can get you back here again. The toughest cases for the court to decide.
I think I don't know about toughest, but the ones where you feel the most weight are the ones interpreting the United States and Minnesota constitutions. I mean, they are fundamental governing documents. They're extraordinarily important. When you're really trying to figure out, against the backdrop of U.S. Supreme Court decisions, do we follow the U.S. Supreme Court decision? What will be the law of the state of Minnesota? Those are the ones where there's the greatest weight. And I've been on the other side of the bar on those, and but I don't think you can appreciate how challenging they are till you sit down and do it.
Justice David Lillehaug, Associate Justice, Minnesota Supreme Court.
Thank you,
Come
Alan.
back soon.
Thank you,
and
sir.
Thank you so much.
Good to be with you.